patents in Japan.
Thank you for coming today. And I'd like to talk a thank for the Hong Kong University, particularly Dr. Reyes, to providing this wonderful opportunity to do the presentation in this place. So I'm Takayoshi Saito. I come from Chuo University in Tokyo. And if all goes well, I will going to law school in next spring. And I am very honored to speak here about my favorite topic, patent issue, particularly patent law program in Japan, which is my presentation title. My topic today is whether patent law will target Japanese companies, and if so, does Japanese society need to take action to deal with patent laws? For this presentation, I will look at patent laws action in the United States and compare these to the Japanese situation. Then I will consider whether Japan need to take an action to deal with patent law or not. First of all, what is patent law? There's no clear legal term in English or Japanese. According to Peter Deketon, who is a counsel at Intel Corporation, say a patent law is somebody who tries to make a lot of money off a patent that they are not practicing and have no intention of practicing, and in most cases, never practiced. However, some people disagree with this definition. In this presentation, patent law means groups having 4 characteristics. First, they get patent from companies. They play no role in invention. Second, they don't have intention, ability, or institution to implement their patent. Third, they choose target, send warning letter, and sue their target. If successful, they can get large sum of money in damages or settlements. Fourth, some specialists engage in groups. For example, engineer who can find profitable patents, sleeping patents. Experienced lawyer for negotiation and litigation, and certified public accountants who are trained to calculate damages. And these days, some groups have one more characteristics. Financial specialist engaging the group to make a fund using for trial. Also, psychologists engaging the group because they get to settle easier and earlier. Next, how to patent laws earn money. Patent laws decide the target and purchase a patent that's possible for target to infringe from inventors, either individual or companies. Patent laws send warning letter and they request making license contract or buy their license. If target ignore or disagree with this offer, patent laws sue them. If patent laws win in the litigation or get into settlement, patent laws obtain money. From target company, it is difficult to make cross-license contract because laws do not implement. Also, if the court declare injunction, the target company suffer huge amount of damage. In generally speaking, patent laws are negative for society, in particularly manufacturers. Patent laws are active in United States. According to the report by United Patent, that is US Patent Aggregation, the number of patent action is more than 5,000 in year, and that is the largest number in history. From this report, NPE, in other words, patent trolls action are 66.9%. In Japan, there is no statistic of patent trolls. Also, it is hard to see the action of patent trolls, and it isn't popular in Japanese society. When I talked about this presentation with my civil law professor, he said, "What is a patent troll? Does it come from fishing?" Some people think the risk of patent trolls actively in Japan is low. It is difficult for patent trolls to do action because of patent system, the juridical system, and the cost problem. Let me compare the situation between Japan and the US for 3 areas. First, patent to be granted system. Patents are granted easier in US than Japan. in Japan. Why? Invention patentable is wider in US than Japan. According to US patent code, whoever inventors or discover any new and useful process, machine, manufacture, or composition of matter, or any new useful improvement thereof may obtain patent, therefore subject to condition and requirement of this title. Also, according to the code in US, without nature, physical phenomena, and abstract ideas, Congress has intended to patentable subject matter to include anything under the sun that is made by man. From this criteria, it is easy to grant software patent and business method patent. On the other hand, in Japan, innovation in Patent Act means the high advanced creation of technical idea utilizing the law of nature. From this article, invention that granted for patent should be required utilize the law of nature. It is difficult to be granted business patent. In addition, software patent examining is stricter Japan in US. According to examination guideline for patent and utility model in Japan, software patent need concretely performing by hardware. The second point is the criteria of non-obviousness in US. According to Japanese Patent Act, the non-obviousness means inventive steps of the invention. Before 2007, US court adopted a strict test of teaching, suggestion, or motivation test, or TSM test. If non-obviousness is admitted, it needs to other unpublished materials as evidence. Therefore, it was difficult to observe non-obviousness. On the other hand, in Japan, according to Japanese Patent Act and guidelines, it doesn't need other patent and published material. Therefore, examining the inventive steps of invention was easier US than Japan. For those two, generally speaking, it is easier to be granted patent in US than Japan, particularly business patent and software patent. As a result, two phenomena occurred more US than Japan. First of all, the number of patents and the risk of patent infringement have been increasing. Second, examiner can't reject due to strict TSM test in the United States. The risk arises where the quality of some patent became poor. then the risk of patent infringement and relating litigation are also increasing. The third point is the difficulty of challenging patent validity. It is harder US than Japan to challenge validity of patent. US Patent Act provides a patent shall be presumed valid. If a defendant disputes invalidity, he has to prove clear and convincing evidence for invalidity of the patent. What's more, if target companies get into contract with patent troll, then target companies dispute validity of patent. The court don't start the trial because, according to Japanese Supreme Court in US, when licensee sue licensor by challenging validity of patent, there is no reasonable apprehension of suit. What's more, if target company dispute patent invalidity, it needs long time and huge cost. The fourth point is US Patents Act didn't adopt non-exclusive license based on prior use, while Japan adopted this. This means X invents an invention and implement or prepare for implement before Y invents same invention, and Y's invent is granted for patent. X don't need to obtain a patent license from Y. X can use his invention only for the purpose of such business worked or prepared. On the other hand, US adopted first to invent principle. There is a notion about exclusive license based on prior use. Before Patent Act was amendment in US, the defendants couldn't dispute the right for the patent law. The second area is juridical system. The first point is jurisdiction or issue of forum shopping. The patent law can select their favorable court by long-arm jurisdiction. When patent law, that is New York, can sue company who is in California, it can go Texas court if patent law or target company have relation in Texas. In US, from United Patent Corporation survey, more than 44% of cases sued in Texas court. Why? Probably this is to do with the prevailing rate. In 17% of patent litigation in Texas, plaintiffs win. As a result, Texas is extremely favorable for plaintiffs, including patent trolls. On the other hand, in Japan, Osaka District Court and Tokyo District Court deal with patent case. These courts have special session of intellectual property case. In addition, prevailing rate of Japanese patent case is 25%. Compared to US, prevailing rate is lower. The courts try to be impartial. Neither favors the plaintiff nor the defendant. The second point is the way of claim interpretation. In the United States, when the court interpreted claim, they usually followed dictionary or general meaning of terms. What's more, in general, the court denied limited interpretation without function claims. On the other hand, in Japan, the Patent Act says the meaning of each term used in the scope of claim shall be interpreted in consideration of the statement in description and drawings attached to the application. In other words, it may be considered as a more flexible or adaptable to reality. In addition, the Supreme Court can't adopt limited interpretation to interpret the claim. Therefore, in general, Japanese court interpreted the claim narrowly. The last area is the cost problem. The first point is difference of amount of damage claim. Generally speaking, awarded damage is higher US than Japan. $74,000 is the largest case in Japan. There are two reasons. First, US offer punitive damage. If patent infringers are willful of infringement, they have to pay much money than compensationary damage. On the other hand, Japan don't offer punitive damages. What's more, the amount of damage is lower Japan than US. In total, damage is based on lost profit. When the court calculates lost profit, it often uses contribution rate of the full price of product. The second point is issue with languages. For the non-Japanese patent trolls, the cost of hiring Japanese lawyer or interpretation fee can be problem. In essence, they need extra money to litigate. The language in Japanese court, it should be used Japanese, and only Japanese qualified lawyer do act in the court. Non-Japanese patent trolls should hire Japanese lawyer who will understand IP case. What's more, Japanese lawyers don't always speak English fluently. It often needs interpreters. In addition, for lawyers' fee for success aren't popular in Japan. If patent troll hire lawyer without any special condition of contract, you have to pay initial cost that doesn't refund even though patent troll failed to litigate. The last and most important point in the US court system is adapted discovery. Discovery means each party should show all evidence relating to the trial. If target company failed to do that, they suffered monetary sanctions, including punitive damages, evidential and testimony limitations, or other things. In discovery, target company sometimes spend tremendous cost to gather information and attorney fee. For this reason, target companies make settlement with patent troll. On the other hand, there is no discovery system in Japan. There is no most effective weapon for patent troll in Japan. For this analysis from Japanese patent system, cost system, and cost problem, some people say it is difficult for patent troll to act in Japan. In my opinion, also for the Japanese situation, patent trolls will not be active in Japan as well as US. So my question is, don't Japanese companies need to prepare for patent trolls? No, Japanese companies should be cautious for the patent trolls. Cautious. Japanese companies should be cautious for patent trolls. That's because there is a risk that the number of Japanese and non-Japanese patent trolls will be possible to increasing. There are 5 reasons. First, Trans-Pacific Partnership or TPP will be launched. One of the aims to TPP is duty-free trading. Possibly, the closer economic relationships, the more number of non-Japanese patent troll is increasing. There is a possible risk to the number of companies coming to Japan along with patent troll. The second point is governments of Japan promote pro-patent policy from 2003. That means an inventor isn't granted became a patent. Innovation isn't granted became a patent. Implement and or using patent make money, then inventor makes more invention using the money from patent. As a result, the number of granted patent is increasing year by year in 10 years. According to the situation, some companies or individuals transfer patent to make money and patent trolls obtain patents. The third point is injunction. According to Japanese Patent Act says, if injunction is admitted, it automatically stop making products or other things. So patent trolls may try to get into settlement by these provisions. The fourth point is prevailing rate. Before I said Japanese prevailing rate is 25%. However, according to representative of IP High Court in Japan, including settlement in trial, 40% is substantive prevailing rate. Texas Court prevailing rate is 70%, of course not including settlement. However, Japanese substantive prevailing rate is not low. The last point is Japanese cultural background. In general, Japanese people reluctant to go to litigation. Target companies sometimes make license contract or settlement. I introduce case in Japan, and I disturb the reference. Oh.
You want the original one?
Original one. Yes.
I think so.
Just one page. Just one page. ごめんなさい、これちょっと向こうに。Okay. Okay. So in this case, the problem is the dual display like this. It's using for the mobile phone. In Japan, ADC technology, this company established in Japan and obtained dual screen patent using for mobile phone or portable video game player from the Netherlands company. Then it sued NTT Docomo, that is a carrier of mobile phones, and NEC, that is manufacturer of mobile phone. Company said Docomo and NEC infringe ADC company's patent. ADC is a software company, and it seems to be inventing some software. However, the company's main business is license business. It buy patent from inventor, make license contract with other company, and get the profit. In the litigation about dual screen patent, ADC lost because ADC's patent is invalid. ADC lost this litigation. However, they succeeded to make a license contract with 9 companies before litigation. As a result, when patent trolls send warning letter for the company, some target companies surrender patent trolls, or companies search and buy patent from patent trolls before patent trolls take an action. I'm not sure why 9 companies make a contract with ADC. It, however, possibly to be Japanese cultural background. Japanese people don't like litigation. According to the situation in Japan, there is a risk to patent troll actively. For this situation, Japanese companies should prepare for the patent trolls. So how does Japanese society prepare for these programs? One is a legislation applying to the United States House of Representatives. For example, the necessary condition of injunction became stricter. But it, however, is unfavorable. It is difficult to define what patent troll is, and sometimes the patent owner doesn't patent trolls and really need to remedy won't dispute injunction. For the target company, when patent troll attacks them, it is the best way to go to the litigation. It is the best way. Before I talk, Japanese patent re-examination system, Japanese court system, and Japanese Patent Act and are not familiar with patent trolls than US. When target company received warning letter and target company think there is no reason to infringement of patent trolls patent, they should take action for the patent invalidation trial and or debt absence confirmation litigation. When patent trolls sue them, they should dispute patent invalidity. In addition, patent re-examination is one of the effective ways if target companies have evidence. Target companies shouldn't take easy to make license contract or settlement. Once they do, target companies are labeled as an easy target for the patent trolls. In addition, target companies should do the patent watching. It, however, is sometimes difficult for the companies to watch patent trolls act because of their resource and budgets. So patent pool or patent aggregation is effective to protect by patent troll. Patent pool means 2 or more companies establish the group. Its main purpose is easy to manage patents. And some patent pools in the United States watching patent trolls action. Also, special license system is adopted. For example, X and Y join a patent pool. If Y sells their patent for the patent troll accidentally, when Y sells a patent, X was licensed to use Y's patent automatically. Patent trolls can't sue X. Patent aggregation means 2 or more companies make a group. It purchases a patent from inventor, not including patent troll. The purpose is reducing the risk of patent action, including patent trolls, when they do the business. In my conclusion, we see the action of patent trolls in Japan. Frankly speaking, thanks to patent system and juridical systems, the number of patent trolls will not increasing as US. However, there are risks to be increasing action of patent trolls due to mainly economic situation and cultural background. You need to prepare for patent troll before they are active in Japan. Thank you for listening to us today, and thank you for Hong Kong University and Professor Reyes. Thank you very much.
We have a little bit of time, so that I'd like to invite questions from everyone, whatever questions you might have. Yes, Ron.
Yep.
Hi, I like your definition of patent trolls, really good definition. My former
Perhaps Ron
student,
could just speak a little louder.
sorry, my former student was actually a patent troll. I thought of inviting him in, but I wasn't sure he'd feel comfortable. But
You had a former student who was a patent troll.
yes, he didn't call himself a patent troll. He called himself a NPE because he didn't like the word patent troll. But
Yeah.
He was just making the market more efficient.
yes.
Yeah.
Actually, I'm curious. You said there are not many patent trolls in Japan. What about patent trolls that are taking action against Japanese companies outside Japan? For example, there's a case in America right now. It's not a patent troll. Van Silicon, they're not a patent troll, but they're taking patent troll-like actions against Honda, their suppliers, I believe Toyota and BMW also. And so they're attempting to get an injunction to prevent Honda, Toyota, these car companies from actually selling their products because of infringements of their electronics patents. Do they have statistics on patent trolls or taking action against Japanese companies outside Japan, and how are the Japanese companies reacting? Because it's actually would it be the American management who is taking care of the problem, or is it the Japanese management? So just curious of that.
So in some reports says some report introduced the case outside the case of the patent troll actions, but there are no formal statistics in here, and also the number of the Japanese companies think patent troll is not domestic problem, just outside problems, and they prepare for the patent action, as you know, the patent aggregation, patent pool.
Other questions? Yes, Albert.
I don't know anything about this area, but so my question may not be a very good question. But in the example you gave, this paper, you said that the court decided that the patent was actually invalid. So I didn't fully understand your definition of patent troll. Does that mean that in all patent troll cases the patent would be invalid, or only in some cases? Can you repeat your definition of patent troll so that
Patent trolls?
we can
Troll,
hear it?
troll,
Patent
troll.
Patent trolls. The four characteristics in
Definition.
definition. Definition, and the first from the
Your definition.
my definition. My definition is mainly four characteristics have groups. The groups have four characteristics.
Yes.
The first is they get patent from companies. They have no rule in invention. They have not make an invention.
You mean they get a patent even though they have not made an invention?
When a company goes bankrupt and a company, say, has certain patent rights,
Yep.
then one of these trolls can come and bid in the bankruptcy, in the insolvency of that company, and acquire such patent rights as the company may have had. They claim they have no role in the patent itself. They buy it up at a
Okay.
very low
Yes.
price and then seek to exploit it for their own ends.
Yeah, so those patent rights may well be valid.
Some may be valid, some
Yep,
may not
yep.
be valid.
Yeah, and can you continue the
Yeah,
definition?
okay. And second is they don't have an invention ability or institution to implement their patent.
Okay.
There is no intention to develop
Yep.
the patent.
No,
They
no
merely want to
manufacturing.
use it as a weapon in order to squeeze out money
No
from
manufacturing.
companies
Yeah.
they accuse of infringement.
And third is they choose a target, send warning letters, and sue their target. If success, they can get large sum of money in damage or settlement. The company's main purpose is getting money through the settlement or litigation.
The weapon for the negotiation.
Yep. And the fourth point is some specialists engage in the group, like lawyers or engineers, who cites the patent.
Yes. So the example you gave was a case in which the patent was invalid, but maybe there are also cases in which the patent was valid, but you still think that it is a problem. Is that right?
Mm,
I think the point being made is this. If you have to go through litigation to establish that the patent that you, the troll, have acquired is valid or invalid, you've basically lost on that proposition, because that makes your attempt at exploiting that particular patent uneconomical. What you're rather targeting is to go for settlements. So if I'm a patent troll, I acquire a cheap patent. I specialize in these things. I look in the newspapers. I look to see the advertisements. I see where the business opportunities might lie. I acquire such a patent. I send out 100, 200, 300 letters to 300 companies saying, you've infringed my patent. 50% will not even bother to reply. Of the remaining 50%, 50% will say, no way, go away. The remaining 50% of that 50% might say, let's talk.
yeah.
And if I get
Yeah.
even 10 of them to give me some money, then
Yeah.
I may make a profit. And then I go for my next patent opportunity. And that's the way I do it. I use my eye for what might be a reasonable patent to use. I don't particularly care whether it's valid or invalid. And then I play with statistics. I send lots of letters out to various companies, and I rely on the very few who respond to me and say, I have a case. You think of the same thing with these, we all receive emails from Nigerian investment companies. Now they send those by the millions to everyone. Okay, 90% of millions will not reply, but a very few will be gullible, and that's all they need.
Yeah. That is a wonderful example. Exactly correct. Yeah. And sometimes patent law sue the big companies, and they sometimes get into the settlement because with in United States discovery, the huge company like Apple have to discover a lot of tremendous evidence, like an email or a memorandum. So it is tremendous cost. So they surrender the patent laws.
So there's also that assists settlement because of the nuisance value. If I have to make substantial disclosure, come on, this guy's worthless, this thing, okay, all they're after is a couple of dollars. I'll give them, here, I give you $100,000, go away.
Yeah.
And that's it, the patent troll has succeeded. Because Apple can't be bothered to do all the millions that it takes in order to make discovery, general discovery in the United States. And Apple can't just be bothered, just pay them off, buy them off. How much? What's the bottom line? That's the sort of thing. And if that's the case, I think Takayoshi's point is this. One, is there any real way you can prepare for this? Because you can prepare all you want for it. But it's the probabilities. There'll always be some foolish, some sucker, shall we say, to use Barnum Daly's term, someone who will be gullible. And that's what you're after. And as long as you can get a few that are gullible, you make your money.
But those who are gullible are not completely stupid, because, so for example, I received such a letter. I will check to see whether the technology which I'm using is
You're not the gullible one, so you see, we're not interested in you.
But I don't know how patent. Do you mean that many companies are actually using technologies which can be easily suspected to be covered by
Not easily
patents?
suspected where it's in doubt. At least there is a question. You can never be 100% sure. There's always a litigation risk. Now, I don't want to go to court if I'm a patent troll. What I'm doing is I'm looking for the very gullible ones who will say, let's talk. And then I do a quick settlement with them. And that's it. It's not a bad business model. There are other ways you can play with probabilities. But this is one way.
So what is the technology in this case which was said to be patented?
In case of the dual screens, so its mobile phone is a old-fashioned mobile phone is one side of display, like not smartphones.
Both sides.
So maybe the company invented this itself, and then somebody said it's the patent.
The Netherlands company get a patent of dual screens, and ADC in Japan purchased the patent from Netherlands company.
It didn't produce any products.
Yeah, almost any.
Oh, no.
Almost any.
Other questions? Yes, Ron.
Sorry, this other.
Edward, you have a question?
Well, I actually don't have a question, but it's more like a comment. So I think this sort of trolling is not really limited to patents, right? It can happen to,
No.
for example, copyrights and trademarks. Because I think this sort of trademark trolling, I don't know what it's called, is
So it's
actually
intellectual property.
Yeah,
trolling.
yeah, it's
IP
actually
trolling.
quite common in China, right? Because
Oh.
I've heard, well, I'm not an expert in IP, so I've heard that companies actually buy all those trademark names and then they wait for luxury brands to come into China and then they say you infringe their right. And one popular example is actually Apple. In the past, Apple used to have like what they call iDevices. They call it iPods, iMacs, and iPhones, and whatever. Nowadays, they don't call them iDevices anymore. It's because of this trademark trolling problem. The case was actually litigated in Hong Kong. So there was this company in China who owned the trademark for iPad, and then Apple actually didn't do the necessary IP due diligence, and they announced the iPad in 2000 and I don't remember. I think it's 2012, and then the Chinese company actually told Apple that you infringed their IP rights, and they're suing for millions of dollars, and they're using this tactic to earn money. So in essence, this sort of trolling is quite similar to patent trolling. So I'm just wondering.
Okay.
Can you comment on that? Actually, what you're talking about is squatting. They either do trademark squatting, or in the case of domain name squatting or cyber squatting, where they buy the trademark or domain name ahead of time and then seek to get the settlement from the legitimate owner. This is a problem in China because China has a first to register trademark system. To answer your question about copyright trolling, there actually is such a thing as a copyright troll, particularly in America. These are companies who are doing exactly the same thing in copyright that their equivalents in the counterparts in the patent field are doing, where they are going after people for saying, for example, you're infringing my copyright right on the song. Now, they're not quite as popular in America as patent trolls because the average damages for copyright are far less than patent damages. Patent damages go into the millions in the United States for various reasons. And so, yes, you do have this kind of a problem, but it's actually a copyright problem. What you're thinking of in the trademark area is really more of a squatting problem. Conceptually, it's very similar. Actually, I had a question for
Yep.
you. This is actually, do you think it might become a problem if Japanese companies start to have problems becoming, not say patent trolls because of your definition, but say non-practicing entities? There's a company in Israel who has now been classified as a patent troll. There's a company called Camel, and what
Just
they
a little louder because.
Camel, I'm sorry,
Yes.
Camel. And what they had done was they had a business model in 3G technology, if I'm not mistaken. And then the market and the technology moved on, and their business model collapsed. So then they had all these patents, so they began suing people for patent infringement. So they became essentially, by some definitions, a patent troll, but more technically a non-practicing entity. Could this become a problem in Japan if Japanese companies, particularly smaller ones, start to have economic problems and they have to abandon their original business model and go after people for suing them, for patent?
So your question is essentially not that Japanese companies would be the subject of attack with patent trolls, but with the Abenomics, with
Yeah.
Japanese companies going bankrupt, insolvency becoming more tolerated.
Yes.
Japanese companies, in order to survive, will become patent trolls. Do you see
あ
that as a possibility in Japan?
あ It is one of the
Business model.
good business. I see. Yeah, so I'm not sure to relating this your question, but it is one of the difficulty of the patent troll program is the patent right is valid and litigation is one of the right or remedies. So it is difficult to decide the patent role. No. The patent the action like patent role is good or not. Yeah. So it is still big problems.
Interesting question.
Yep.
I mean, what you're saying is it is a possibility.
Yep.
You're saying yes, it's a possibility
Yeah.
because patent trolls thrive on uncertainty. It's the very uncertainty of the outcome of patent litigation that would encourage one to, say, a sort of patent arbitrage by becoming a patent troll. That effectively you're doing a form of arbitrage. Other questions?
I've got to
Professor
go
Wu.
soon to take some students to visit a law firm, but can I just quickly ask a question about the business model? I wonder if the business model would only work if, one, the cost of litigation is affordable, is not too prohibitive. Secondly, the target company has a lot of money, have a deep pocket. If you don't have these two conditions, the business model, it seems to me that would be difficult to work. I mean, in Hong Kong, for example, if it costs you millions of dollars to sue, and the target company doesn't have a deep pocket, then it wouldn't work for the patent trolls. Because there's a risk, there's uncertainty.
But it
They
might
might
work
not
the other
win.
way around. If litigation is expensive, both for the claimant and for the respondent, for the plaintiff and the defendant, then it's a cost-benefit analysis for the defendant. Do I settle cheaply, and the patent troll is after a quick settlement? Do I offer a quick settlement, or do I engage in a long litigation, which will be costly? I may win at the end, but even if I win at the end at such great cost, how can I recover my costs from the patent troll? Because these are usually what, $1, $2 companies, or companies on the brink. So it's a cost-benefit analysis for the defendant. And I think it's not necessarily the case where litigation is affordable, but where litigation is very expensive. Then there is an incentive to settle rather than to fight if you're a defendant, however certain you may be that you will win at the end of the day.
But if the target company say, okay, we're going to fight, the patent
Patent
troll
troll folds up.
might say, okay, we wouldn't have a deep pocket to fight with these guys, so they might just give up.
They might give up,
Yeah.
or they just prolong it because it's going to be a shell company. And they say, fine, even if you win, wind me up. I'm nothing.
Shell company, but where do they get the resources to
Funders,
litigate?
third-party funders.
So what's the
No.
main difference between a non-patent troll? That is somebody who is an inventor and who got a patent and who sues, and a patent troll suing. What's the difference from the point of view of the defendant?
The inventor truly wishes to protect his or her patent rights, which he or she usually has spent a lot of time in developing. The patent troll simply acquires rights, has no interest in developing it,
Yeah.
and simply is interested in
But,
making a
but
quick
from a
profit.
point of view of the defendant, it's the same. Whether you are the inventor or somebody who just filed
right.
bankruptcy,
Yep.
from the point of the defendant, it's the same.
Yeah, I think the
Same
point.
consideration as to whether to settle or to.
But the
to
plaintiff
defend.
who is genuinely involved with the patent is unlikely to settle, because the plaintiff who is genuinely involved in the patent wants to establish his or her patent. The patent troll is happy to settle and is happy to settle quickly. I think that may be the difference.
And I think the point is that if the person who sues is the inventor, then we think that that's okay because he's got legitimate interest in that and so on. It's not a problem. Whereas if it's a patent troll, he's there for the quick money. So why should the legal system allow these people to abuse the systems to squeeze some money out of the target company? I think that's the
question. That's the
question.
dilemma.
Yeah. And how do we deal with it?
How is this? I mean, the patent troll would simply say, "I'm making the market more efficient."
Thank you very much. I got to
Oh, okay.
Sorry, I have to take
So
some
it's just
students
like
to
companies
law
buying other debts. Like the company in the Congo case.
Correct.
What is it called? What kind of?
FG Hemisphere,
No. What is this type of?
vulture fund.
Voucher fund. So it's similar to voucher fund.
That's correct. They look for unusual business opportunities. And you buy a debt low, and then you seek to enforce the debt. And if you happen to make it, then you're in the funds. Those are vulture funds. Oh, perhaps one more question. Any question? Yes.
I'm a student studying HKU and I'm studying commercial law, so my concern is about the relationship between commercial law and patent troll. And this is a topic me and some friends of mine are researching into.
The relationship between what law?
Between competition law
Competition.
Competition
Yes.
law.
in the US called as antitrust.
Yeah. So one of the problem is, as I say, the patent pool or patent watching is possibly in breach of the competition law. So the patent pools they get for example, the MP3, it is a sound system, like you use music, and this is in some companies make a patent pool and get the the patent relating to MP3, and if this organization don't license for the other person or other company, in case it is possible to breach of the competition law.
I think the position in US or the consensus is that patent trolls are harmful as a matter of competition law or as a matter of economics. But I have found arguments to the contrary. Some arguments would say that patent trolls are effective because in some sense they are just litigators, they are just law firms. And they would, because the patent trolls, they have to buy the patents from the inventor. And the inventor will get some reward for his invention. Say if the inventor is a small inventor without adequate resources to go to litigation for infringement, then maybe the patent troll is effective in protecting the inventor's human right. In this sense, and it may make sense that most litigations are initiated by patent trolls because in some sense they are just litigators, they are just law firms, agents for collecting royalties, and they're efficient because they are specialized. And they will protect small inventors against large companies, for example, Apple and others. So I'm not sure if this argument holds true, and yeah, I would like to see what you think about this.
It is a very tough question for me.
I'm
So
not sure we can resolve the question.
yeah.
There are obviously arguments on both sides.
Yeah.
Essentially, you're saying that making the market more efficient. We should be grateful to them,
Yeah.
rather than we should be disappointed that there are not enough patent trolls in Japan. That's why with more patent trolls, the Japanese market would be more efficient. But I think we can leave that for discussion afterwards. There's still some sandwiches. Everyone can please help themselves.
Yeah.
Even if you don't drink the water, just take it, go away with it. You have a friend who's gone hungry because the friend, why not take a sandwich for the friend, offer the friend the sandwich, and so on. But before we go, we mustn't forget that we've had a very pleasant, intimate discussion in this room, and we'd just like to thank Takayoshi for giving us a stimulating discussion. Thank you very much.
Thank you very much.